Good morning. Ooh, I'm loud. Just a few minutes before class. So we've got a little bit going on this morning here at Second Pres. The way it's been explained to me is it was either tear up the parking lot or tear up the floor of the sanctuary. So I think they made the right choice, and it's moving very quickly and should be resolved by the end of the week. At least where the parking lot is drivable next week. So, because I know that this is live streamed on Facebook, on our public page, there may be people zooming in or tuning in to see us. I want to let you and our online listeners know that we will be running a shuttle tomorrow morning and Thursday morning just to help with the flow of traffic. So the shuttle runs continuously from Second Pres to St. James and back. It will drop you off right over here by the chapel to keep that clear on the construction side of the building, and will run continuously Wednesday and Thursday morning. The other announcement that is just a business announcement. Oh, yes, Jan has a question. Just on the north side, Jan's asking about where the construction is today. Will probably be that way for a couple more days this week. So that's why we're running a shuttle Wednesday and Thursday this week, Wednesday and Thursday morning. The rest of the parking lot's fine to park in. We have, many of you have heard this 4 times already, but I'm announcing this in as many classes as possible, that we are bracing for impact. The LifeQuest Impact and Evaluation Survey is coming out online and in paper form on Monday, so please check your email. The more of you that can complete the survey online, the less data entry I have to do, but paper is fine. We would rather have as many people participate and complete our surveys as possible. A high percentage rate of completed surveys means that our information is more helpful to us, that we can make program improvements and secure funding for LifeQuest. So know the survey's coming out on Monday. Pertaining to this class, there are some flyers in the back. I can have more made if we run out. I'll go check. This is the speaker, Reverend Paul Brandeis Rauschenbusch, that CALS has invited on November 20th. He is the reason we have this class, is to engage conversation and community engagement around issues pertaining to law and religion. So this is the speaker and the information about that lecture on November 20th at Ron Robinson Theater as a part of the Central Arkansas Library System. So know about that. Today, we have John DiPippa, former dean of the law school, and if you're really, really nice, he might be sweet-talked into teaching a class for LifeQuest in the winter term. The winter term is 6 weeks in length, and the registration for the winter term opens December 9th. That's not the only day of registration. That's the first day of registration, is December 9th. And I'm going to turn it over to John for him to lead us in our topic today. Welcome.
Thank you, Leah. Thank you. Well, it's nice to be here. I'm a little intimidated by the organ, but I faced law students for 38 years. I think I can handle the organ. I'm excited to be here because for many years I taught a specific First Amendment class, and in particular I focused on the religion clauses. So this gave me a chance to remember what I forgot and update some of that. So let me begin. The 10 Commandments, what are we going to do with them? It's an interesting topic. If I know how to, there you go. So here I am. I am John DiPippa. I started at UALR in 1983. I retired at the end of 2021. I am the Dean Emeritus and Professor of Law. Over those years, I taught constitutional law consistently, and as I mentioned, a First Amendment course. I've been married to my wife Karen for 51 years. She's the beautiful woman in the middle there. She also retired. She, for 33 years, had been the director of the Westside Free Medical Clinic for the Catholic Diocese. And I could spend the rest of the time bragging about her and her work. But I also want to mention that we're both avid cyclists, although she's a much better cyclist than I am, including winning several medals at the National Senior Olympics. So my job is just to keep up with her. We've gone to the Olympics, and her job is to win a medal, and my job is not to finish last. And we've been successful both times we've attended. We have 4 children, Joel, Andrew, Micah, and Nikolai, and 7 grandchildren. And that was taken at our 50th wedding anniversary party. So here's what we're going to do today. I keep pushing the wrong button, sorry. There you go. So I'm going to review the First Amendment. I know you've had it all, but it's worth just checking in with it again. We're going to do a quick Christmas diversion. Then I want us to go ahead and take a closer look at the 10 Commandments cases in Arkansas, and there are 2 of them. And then we'll take questions. And if we have time, we'll pay a quick visit to the United States Supreme Court courtroom. So, let's begin. This is not the Christmas diversion. As you know, the First Amendment has 2 religion clauses, and they're divided as typically in the Establishment Clause and the Free Exercise Clause. And so it's worth just spending a minute looking at the text because it's not obvious sometimes what it means. So the first thing that should jump out at you is it says, Congress shall make no law. Well, actually, it's any government through the magic of what's called selective incorporation. The guarantees of the First Amendment have been held to apply also to the states after the 14th Amendment. So that text, Congress shall make no law, actually doesn't mean anything anymore. Then the Establishment Clause comes, and notice the peculiar language, respecting an establishment of religion. And the framers could have said, Congress shall make no law establishing an official religion. But they didn't. And so what do these words mean? That's why this part of the First Amendment, the Establishment Clause, is really difficult to figure out, because respecting suggests something less than full establishment. And then a curious phrase, not the establishment of religion, but an establishment of religion, suggesting, I think, something broader than just a single focus. And so those words have really made it difficult over the years for the court to figure out, how do we deal with this stuff? And by the end of today, I want you to see how the court has tried on stuff and then abandoned it. And now we're left really in an area where no one really knows what's happening right now. And then the Free Exercise Clause follows that. The first question might be, are they 2 sides of the same coin? Are they related? Are they different? Do they cover different conduct? Typically, that Free Exercise Clause has been interpreted to mean personal activity, as opposed to, say, the government establishment. The Free Exercise Clause protects an individual liberty. Okay? Again, a curious phrasing, prohibiting the free exercise thereof. Does that mean if the government says you can't practice your religion, that's the only thing you're protected against? Over the years, the court has essentially read prohibiting to mean substantially burdens. So the First Amendment, at least this part of it, really doesn't mean literally what it says. So let's take our Christmas diversion now. You may remember, or you may notice, that every year on the grounds of the state capitol, there's a manger scene or a creche display. And for many years, it was the only one there. And it was prominently displayed, usually at the front steps of the Capitol. There were numerous complaints and some lawsuits filed. We went through a lot of iterations. At one time, this setup paid for by private funds, was outside of Governor Huckabee's office. Eventually, a lawsuit was brought and it was settled. And the Secretary of State came up with this plan. And the plan says, basically, there's 4 plots available on the South Lawn, 30 days before Thanksgiving, no more. You can apply on a first-come, first-served basis. And then the Secretary of State must grant you the permit unless it's unsafe, permanent, disruptive, or destructive, or beyond the limits of free speech. So I suppose you couldn't set up a porn site on the state capitol grounds, but something less than that, I assume, is okay. Well, immediately, the Arkansas Free Thinkers published went to put up the box of wisdom. That's that thing on the bottom. And the Secretary of State at the time said, "Oh, no, you can't do that." They said, "Well, why not?" He said, "Well, you know, it's not in the spirit of things, not in the spirit of Christmas." Again, they threatened him with a lawsuit, and then they settled. And so now, and you should do this year, go drive by the Capitol on the South Lawn, and these will be the only 2 there. No one has ever applied for the 3rd and 4th permits. Now, if you have time, maybe you can. Put up your own sort of holiday box or something. So that's the first little Christmas diversion. Arkansas is no stranger to this stuff. So I want to talk about our 2 Ten Commandments cases, because we have 2. One involves a monument on the grounds of the state capitol, and then the other is the one I'll spend more time on, and that's the Ten Commandments displays in classrooms, public school classrooms. So let's start with the newest Arkansas law, and then I'll circle back to the Ten Commandments monument. So the newest Arkansas law is pretty specific. Every public building, college or university or public elementary and secondary school, and here are the operative phrases, must prominently display, that's important, in a conspicuous place, a donated copy or framed copy of a, and these are the words in the statute, historical representation of the Ten Commandments. Now, that's going to matter when the case, as you'll see, is in court. And then each of those places listed must have this durable copy if it's donated, but it must be put up in every public school library and classroom. And so presumably public buildings can have 1 copy, maybe at the entrance, but every public school library and classroom may or may not include universities. I'm not sure it does, but some of the universities are assuming it does. Every classroom must have a poster, 16 by 20, that can be seen pretty much from anywhere in the room by a person of average vision. Okay? And so there are lots of groups who have created these copies, get to you in a second, created these copies, and they're donating them in the hundreds to schools and universities. If the school has more than they need, they can donate them to other schools who don't have them. Yes, sir? How do you do that in a library? Right. So the question is, it makes sense if you think about the conspicuousness of the display in a classroom because it's fairly confined, but a library has multiple aisles and stacks and things like that. How does a librarian decide what's conspicuous enough and prominently displayed? I don't know the answer to that. Maybe at the door? Yes, it does. Yes, it does. It says it must be legible from anywhere in the room by a person of average vision. So this is the text. Now, it's pretty small, but it's the King James Version of the Ten Commandments. Okay, and You're probably familiar with those, may have seen them once or twice. So that's the text that must be on this poster. It's also the text that's on the monument on the state capitol grounds. And it's also the text that's on the monuments on the grounds of the Texas state capitol, which matters. So let's talk about the Ten Commandments cases, right? You'll see that the context of the Ten Commandments display really matters, and that history mattered a lot. Now it matters a real lot after the last several years. So context and history matter. Context helps us explain, in some ways, what the purpose of the display might be. Right? And history, according to the court, explains whether or not the display is consistent with our historical traditions and therefore has been accepted as an okay practice under the First Amendment. I do like the "no one before me," seriously. That's the modern translation. So you may be aware that there are different versions of the commandments. And so I've put up just the three, and they're paraphrased a bit, but they capture most of the essence. The Jewish version, Catholic and Protestant. One argument in favor of these displays is that, well, the differences aren't that significant. We can all sort of agree on what they mean, except that the differences might make a difference. There's a difference between "thou shalt not murder" and "thou shalt not kill." There's a difference, and I think you can theologically argue, there's a difference between having no graven images and not having any gods before me. It seems to me, I think Calvin argued that the graven images commandment banned statues of saints and things like that. So there are theological differences in the choices one makes here. And what's interesting is that a case we'll talk about, Stone versus Graham from Kentucky, the legislature appointed a committee of various denominations and religious groups to come up with an acceptable version of the Ten Commandments that they could post in public school classrooms, and they couldn't agree because these differences matter, right? I mean, they matter because belief matters, and if you are a practicing member of a denomination, you're not going to say, well, it's close enough, right? And then, of course, Christianity isn't the only religion with a list of things to follow. And so there aren't 10 of them there, but lots of religions have lists. So that's not a terribly unusual thing. So now let's come back to Arkansas, focus in. I think I'm in your way. Am I blocking your? Okay, good. Let's focus on this case involving the Ten Commandments in the classrooms. And that's the Stinson versus Fayetteville School District. And there were 4 school districts in this case, including Fayetteville. They went to the district court, federal district court, and got the displays enjoined, banned, and then ordered removed from those 4 districts. Not statewide, because typically when a court orders relief, it only gives relief to the people who ask for it. Okay? So some other districts have now joined the case. So we have a kind of patchwork where some districts have the displays and a smaller number do not, because they're under this case. So the court held that the display, the law here, was obviously unconstitutional, per this earlier case, Stone, and that it was part of a coordinated effort to inject Christian doctrine in public schools. And it joined Louisiana and Texas in passing almost identical laws. There are some differences. And courts in both of those cases have also enjoined the displays. Okay. So what does the judge mean by part of a coordinated effort? Well, I think that's pretty obvious since you have similar laws being passed in different jurisdictions, all patterned after one another. And particularly in Arkansas, it seems like it's a direct attempt to get the Supreme Court to reconsider Stone versus Graham, the earlier Kentucky case. So there's nothing wrong with that. There's nothing wrong with trying to get the court to review its older decisions. But it is part of this coordinated effort, which may go in part to the purpose and the seriousness behind some of these laws. So let's go back now to Kentucky, and let me give you the background of that Stone case, because that's really crucial for the Arkansas decision. So in Stone, the court held that a Kentucky statute requiring the posting of the Ten Commandments, purchased with private contributions, on the wall of each public classroom in the state did not have a secular legislative purpose. The court said that the purpose was plainly religious and was therefore unconstitutional. Now, that secular purpose comes from a case called Lemon versus Kurtzman. And you may have heard about that. I'll come back to that because that matters ultimately in the outcome. So the Supreme Court in this case issued what's called a per curiam opinion. That is, there's no single justice that signs on as author. It comes from all of them, per curiam. And it was very short. Those are usually issued when the court says, hey, there's not much going on here. We want to get rid of this quickly. Or they're issued when the court wants to make it clear that the court is speaking, not any individual. The Supreme Court did that in a case from Arkansas, Cooper versus Aaron, in the desegregation of Central High School, where they essentially told Governor Faubus, you have to obey federal law. And they wrote that opinion as a per curiam to send the message that we are unified here. This was not unanimous, however, and there were a couple dissents who reprised or actually previewed the arguments we hear today. So Stone goes on to say, in this Kentucky law, the legislature required that there be a statement underneath the Ten Commandments that said, it's the foundation of our law and government. And that had to be under every one of these posters that would be in every public school classroom. And the court said, such an avowed secular purpose isn't enough to remove the religious nature of the Ten Commandments. One, the first few commandments are plainly religious, right? It's hard to see how there shall be no God before me has any secular counterpart, although there used to be blasphemy laws, so it's not entirely wrong. Still, those first several are religious in nature, and while the latter are can be seen as non-religious, right? Don't steal, There are lots of ways you can teach about the connection between the Ten Commandments and law without posting them on a classroom, say in the math classroom. You can introduce them, as the court said, in history classes, comparative religion, ethics, philosophy, even literature. There are lots of ways to teach that. And if that were the purpose, to teach about the law, the court suggests you could do it if you wanted to. It doesn't make sense to say we're teaching you about the foundation of our government by posting simply a poster of the Ten Commandments. So, plainly religious with no legislative purpose. And then the court goes on in this case to say it doesn't matter that they're privately funded or donated, because it's the state law that makes this possible. It's the government authorizing this to happen. That's the state action necessary. If the state says, I'd like you to donate money so we can violate the Constitution, that wouldn't make any sense. And that's essentially what the court's saying here. You can't privatize your violations of the Constitution. Nor is it significant, the court said, that they're just posted and not read aloud. That they're just passive. That's another important term that comes up later. Because the court says it's not a defense to a constitutional violation to say, well, we're just violating them a little bit. Not a whole lot, just a little bit. Just because they're up there and not reading them out loud, the court says, what are they there for if they're not at least having to be something to do with what the students are doing in the school? The court said, look, they're there so the students can read them, meditate on them, venerate them, and maybe adhere to them. What would otherwise be the purpose of posting a sign? If you have an exit sign on the door, that's to show you that it's an exit. You don't ignore that sign and say, well, I'm going to go this way, although I know people who will. Okay. So that's the Stone case. So that was early 1980s. Now, there's another case about the same time from North Dakota, right after Stone, that was in a district court in the Eighth Circuit, which is the federal circuit Arkansas is in, that also dealt with the same kind of statute. And that court said, nah, same thing, no secular purpose. I couldn't find a case where a court has upheld a Ten Commandments display in the public schools. Now, they've upheld them other places, but there aren't that many, but I just couldn't find one where it was upheld. So these are the other two Ten Commandments cases the Supreme Court has decided. And they have direct bearing on one part of our discussion and indirect bearing on another. And so on the same day, in 2005, the Supreme Court decides two cases involving almost identical displays of the Ten Commandments. One from Kentucky, one from Texas. 4 justices would have struck down both of them, and 4 justices would have upheld both of them. 1 justice split his vote. And so the law is essentially what Justice Stephen Breyer wrote in these opinions. Now, I used my right hand and my left hand deliberately, because you can guess which side of the spectrum the judges were falling on, right? So in Kentucky, this involved a display outside, sometimes inside, there's a long history of a courthouse. And it had gone through several variations. First it was inside, then it was outside. It was set up, it was actually inaugurated with an expressly religious ceremony, religious speakers. The legislature that passed it said, we're doing this because we want God back in our country. Sort of a lot of that. And Justice Breyer and the other 4 justices said, no, look at the history here, right? It clearly shows that there's no secular purpose, that it was done for a religious purpose. The history of that shows that. It's brand new, hasn't been there a long time. You can read the statements of people who are in favor of it, and it's pretty clear this is all about religion. Same day now, in Texas, the court says, well, Justice Breyer said, okay, it's okay. What's the difference? Well, that one in Texas was donated by the Eagles fraternal organization, and they donated a bunch of those throughout the 50s to states and municipalities, that it was on the state capitol grounds. There were a bunch of other statues and displays on the state capitol grounds. I think, if I remember correctly, there were 39 other ones, all sort of celebrating some aspect of Texas history. And Justice Breyer said, well, you know, at worst, This is a mixed purpose case. At worst, it's got religious and secular purposes. But on balance, we got to lean toward the secular part of this. First, it's been there a long time and nobody complained. Second, it's clear that it's there in a context in which other things are talking, at least the state is making points about other parts of its history. And it's not a standalone like it was in Kentucky, and there's no history like there was in Kentucky about this being overtly religious. So the court's, again, Justice Breyer says, look, it's okay to acknowledge religion's role in our history, and that's what this is doing. And it's clear, at least to him, that that was what the purpose primarily was because of where it was located, how it was set up. Okay. Well, let's go to Arkansas now. You may remember that Arkansas, for one day, had a Ten Commandments monument on the state capitol grounds pursuant to a state law donated, set up without state money. And then a man with mental illness drove into it the next day and knocked it over. The picture now shows the barriers that are in front of it. Now, this case, challenging this, was filed in 2018. It's still ongoing. I'm not sure what's going on with it. I couldn't find any recent docket entries. There have been a lot of changes. Obviously, secretaries of state have changed, so you have to substitute new parties. At least one of the original named plaintiffs has died. So I really am not sure what's happening, except it's kind of moribund. Now, this is a harder case than the Ten Commandments in classrooms. Remember with Kentucky and Texas, right? And so this one has elements of both of those cases. One, there's a lot of religious talk about it, even when it was set up. On the other hand, it's on the state capitol grounds, and there are other monuments there. It's identical in format to the one on the Texas state capitol grounds. It's hard to see how you can parse out what the purpose is. If you read the Texas case as saying the context really matters, then the context wins. But if you read Texas and the Kentucky case to say, well, it's got to be there a long time. There's got to at least have some history where it seems to become part of the furniture and people see it less as a religious monument and more about just another statue on the state capitol grounds. If you read it that way, then putting one up when there never was one before would make it unconstitutional. So I've always said this is a really hard case, and the court doesn't really help you much because when they say, well, context matters, how exactly? And there are aspects of everything here. Maybe that's why it's moribund, but I don't know. But that's where it is. It's still there, obviously. And then, of course, you may also remember that immediately after the law was passed and the monument was put up, the Satanic Temple said, well, we're going to come by and ask for permission to put up this statue of Bahamut. Right? They never did, but I think part of that was to sort of dare the state to say, no, you can't do that, and establish the religious nature of the complaint. Or part of it was just theater, and it was fun to haul that statue around. Okay, so now, moving closer and closer to today. So we've got this Lemon versus Kurtzman test. You've probably heard about it. It set up these three parts to decide if there's an Establishment Clause violation. Is there a secular purpose? Is the primary effect to advance religion? And if there's excessive entitlement. Nobody ever liked it. The court didn't always follow it, and essentially refined it into non-existence over the years. Justice Scalia, who has a way with words, said, well, the lemon test is like some ghoul in a late-night movie that repeatedly sits up in its grave and shuffles abroad, and after repeatedly being killed and buried, it stalks our jurisprudence, frightening little children and school attorneys. Safe to say he didn't like the lemon test, right? So here's a recent public display case that I think provides the foundation for what's happening now. And this was a 40-foot cross. It was on government land, but it was in an intersection. I think you can see that on the top there in Maryland. And the court said, well, it's okay because long-standing monuments are presumptively constitutional. We'll keep that in mind when we talk about both Ten Commandments cases in Arkansas. And that there are 4 considerations. What's the original purpose? Has the purpose and meaning of it changed? And that was my suggestion, that people come to look on these monuments sometimes as just part of the furniture and less of its original purpose. And if we remove it, does that appear hostile to religious exercise? Because the First Amendment, the Establishment Clause, says you can't establish a religion, but if we remove something, the court says, well, that seems to be establishing somebody else's religion. At least that's what I think they're getting at. So there you see this original purpose, history showing up. In that case, the justices had nothing good to say almost about lemon, right? It has to die, it never lived, it already died, it's useful, was too rigid. So the writing was on the wall, for sure. Justice Kavanaugh said, I think this is where we're going. I think this is where we are. If the challenged government practice is not coercive and it's rooted in our history and tradition, it's okay. Or, and there are some other aspects to it. Those first 2 are going to play a big role in the Ten Commandments case here. Okay? Not coercive and rooted in history and tradition. Now, this Kennedy case, I'm sure you've heard before, but this is the one that the states, Texas, Louisiana, and Arkansas, are specifically relying on to say things are different and these new Ten Commandments laws are okay. And so there you see the court upheld this coach praying after the game. They said the prayer was short, private, personal. No students were coerced. You focus in the future on historical practices and understanding. Significantly, in this case, Justice Alito, who wrote the majority opinion, said, well, this would be different if it were in the classroom. Never mentioned Stone versus Graham, but he said, oh, but see, the classroom is coercive, and therefore it's different. This doesn't apply to that situation because this was after the game, nobody's in class, nobody has to be there. Okay? Last term, the court decided a case, Mahmoud versus Taylor, where they allowed some parents to opt their kids out of lessons that they said offended their religious beliefs. Those lessons tended to be about gender identity and LGBTQ, etc. And Justice Alito, writing the majority opinion, says, you know, the classroom environment is inherently coercive because you've got teachers and you've got the whole thing and you have to be there. Parents have to send their kids. They can't just keep them home. And so it's clear that classrooms are different. At least up to now, they are considered different. And there's an earlier case involving a prayer at a school, middle school graduation, where the court said, look, graduations are like school functions, and there's a coercion involved in getting kids to be there. They don't really have a choice, and peer pressure is itself coercive. You don't want to put a child to a choice of missing out on something important because of religious beliefs. So now let's talk about the Arkansas case. And this is the Stimson analysis. Judge Brooks says, well, Stone is still good law and it controls. Why? Well, even if this Lemon test has been abrogated, it doesn't necessarily undo every case in the past that relied on it, and particularly on the purpose part of this. So the judge said, look, this Stone case is still good law. Even if it isn't, the state loses under the new test. And even if they lose on those, the state's going to lose on free exercise. So, let's compare Stone to the Arkansas law. Practically identical. Certainly the text is identical. Arkansas doesn't require the context statement, which arguably makes it a weaker case than Stone. Doesn't matter if it's private. Arkansas says they're donated. And doesn't matter if it's just posted or read aloud. The state has argued in this case that, well, this is just a passive display, which of course was rejected in the Stone decision. Doesn't matter if it's passive, if you've got it in school in a coercive environment where kids are going to look at it. Why else is it there? So, as we would say, on all fours, Stone seems to control this outcome. There's very little to distinguish them. Now, the state's going to argue, well, all the cases that relied on Lemon are no longer good law. Okay, fine. Then Judge Brooks says, well, let's take up the new test. What's the historical practice and understanding, and is there any coercion? Well, the plaintiffs in this case called an expert, a law professor and a legal historian who specializes in this, and he testified that there's really no evidence that there's a long-standing history of posting the Ten Commandments in a classroom. And even if there were, the Ten Commandments, the choice you make, is itself sectarian. That is, it chooses a particular version, one followed by Protestants, as opposed to other versions. And even if that weren't true, that testimony was never rebutted. The state didn't put on an expert. I'm sort of puzzled as to why the state didn't even try, unless they think that they don't care what the lower court rules because they're on the way to the United States Supreme Court and they don't want to cloud the record with other stuff. That could be their choice. And so the framers wanted to protect conscience and didn't want to put people to the choice of having to choose following their conscience over government approval. But even if there isn't a good history here, coercion matters. Again, go back to the classroom, right? The court has consistently said the classroom's different. The classroom has a kind of coercive environment because of adult presence and the role models that teachers are and the authority that principals have, et cetera, et cetera. And then the court quotes from Stone about what's the purpose other than to meditate on, venerate, perhaps obey. And so this judge says, looks to me like the state's going to lose under any Establishment Clause test. And then he looks at free exercise, the second part of the First Amendment. And the Free Exercise Clause, according to current law, says a law that's not neutral as to religion. Well, this one isn't neutral because it mentions the Ten Commandments. That may be a point where the state can appeal, since it mentions the Ten Commandments, but its neutrality depends on how you see the display, how you see whether or not the display is religious. In any event, the judge says, well, look, it's not neutral. It's a religious display. Therefore, it has to see if it substantially burdens the plaintiff's religious practices and beliefs, It does, interferes with the free exercise in those several ways. And then the court says, well, if those first two things are true, then we test it by what's called strict scrutiny. That means that the state almost always loses. That's the very technical way of explaining strict scrutiny. State almost always loses. Why? Because the state has to show that the law has a compelling purpose, not just an ordinary purpose, but one of the most important things a government can do. Compelling. Very few of those. The court says, I don't see any compelling purpose here. On the other hand, even if there were a compelling purpose to teach children about our history, which could be compelling, it fails because the second part of the test requires governments to achieve this compelling purpose with the narrowest means possible, the ones that are least burdensome on rights. And so you can see obviously here that a narrowly tailored, less burdensome approach would be to teach about the Ten Commandments in a history class. Ethics, comparative religion, all those things. So if the goal is to teach about our legal system, then you're not doing it in a very narrowly focused way by putting up posters in every classroom. So they lose under the free exercise clause too. Let me add a couple last few comments and then give you some time for questions. So on the purpose part of this, because notice that if Stone is still good law, it's good because this purpose standard still applies. Well, really think about this. How do you determine the purpose of a group of people, not all of whom are going to tell you what their purpose is? It's a legislature, right? Justice Scalia also wrote, who knows what the purpose is? Maybe they just got up on the wrong side of the bed. Maybe they have indigestion. Maybe they weren't paying attention. That's a little overstated, but you see the problem. Right? Because it's not just any particular person's purpose, it's the legislature's purpose in adopting the statute. And so in Stone, the court didn't even grapple with that. They just said, well, it's obvious what the purpose is. Why is it obvious? Well, it's obvious because there would be other ways to accomplish this goal. But if there were other ways to accomplish the goal, then we're talking more about free exercise, that narrow tailoring thing, than the purpose part of this. And so if I were litigating this case for the state, I would go right after that. I would say, look, this whole purpose thing is madness. Lemon was wrong from the beginning. You can see it's never really made sense. We almost never used this purpose prong. And when we did so in a way that was so cursory that it's hard to know what it all means. Even if you could prove purpose, what evidence do you use? Statements by the sponsor? Statements by the public in support of that? All of that stuff? How do you figure out purpose? In that Kentucky case, they figured out purpose by looking at the history of that particular monument. Okay, what counts as history? Who counts? So I think there's a lot of, as a law professor, interesting questions about what secular purpose means. And don't even get me started on what secular means. Right? You know, Christmas trees, for example, are assumed to be secular. Right? But you dig into it and you see all the religious roots of the tree and the decorations and the star on top, the lights. Right? So if it's secular, it's only because we've forgotten the religious roots. So I think there's a lot of problems there. Now, that doesn't mean the Arkansas case, the state wins. I think the free exercise analysis is on firmer ground because that's where the court is moving, I think, to firmer ground on the free exercise part. So all of that is to say, this will be decided by the United States Supreme Court at some time. So, do you have any questions? Yes, sir.
When you were doing your 4 and 4, I was thinking you can't do that in the current court.
No.
You have to do this.
Yeah, I don't have enough fingers, right.
It seems to me that's a pretty obvious indication of what's going to happen.
So, when I did my 4 and 4 thing using left and right hands, I can't do that with the current ideological makeup of the court. I'd have to have another finger on this hand, and I don't. So that's, as Mike points out, that could be an indication of where they're going. Yes, sir. Sure.
Why that precedent is no longer valid. What's your prediction about if they will honor precedent in these types?
So the question is, this current court doesn't seem too bound by precedent. They're willing to change precedent. And how would I predict the court's going to treat precedent here? Well, what I hear happening is the court confronting the question, because the states are going to say this, that all the prior cases that relied on Lemon are no longer valid. And so they will disregard Lemon only because they have essentially gutted it anyway and finally just put it to its death. Okay? So whether you call that ignoring precedent or simply restating it, I don't think Lemon is going to matter. Now, as I said, the problem is this purpose clause. I hate to go out on a limb too much, but I think the court's going to say, we don't really see an establishment clause violation here. Because if you think about the historical test, it's really squishy. That's the other legal term. It's a very squishy test because, again, what counts as history? How long is a long-standing practice? And you can make an argument that the Ten Commandments have been around in education since our founding. Now, they've been around in private education since we didn't have public schools until the latter half of the 19th century. But how do you parse that, right? Is it that the Ten Commandments have been part of education? Or Ten Commandments displays have been part of public school education? And so it seems to me that I think they're going to come down on that first side, right hand again, and free exercise clause may make a difference. Are we running out of time? We got one more. Yes, sir.
Going back to the coercion that I didn't understand, I could see if you have a football field out in the open, 50 to 100 players, you say a coach might, but as one who played basketball, you have 12 people on a team.
Yeah.
I would have felt I had to go out and participate
Sure.
in prayer if I wanted to be viewed favorably by the coach. I don't see how they said that is a coercion.
So the question is, coercion might seem to be less in a football field situation where it's open air and there's lots of players, and maybe you won't notice if one or two don't show up. But on other teams, like a basketball team, you're indoors, fewer players, and if you're a player, you want to make sure the coach knows you're on board. How does the court deal with that? They don't. I mean, I'll just be honest, they don't really. There's a lot of talk about the coercive nature of the classroom, but, it seems Bremerton pretty much blows that wide open, because if I were on the football team and I knew my coach was praying in a public way with everybody there, I'd want to be there. Just to make sure that, maybe I can get my 10 seconds of playing time, or whatever it happens to be. So, but they don't deal with that. They argued in Bremerton that there's no coercion here because it was a private player, it was voluntary, it was outdoors, after the game, all that stuff. We're out of time.